by now Mr. Lyle Solomon. He's an attorney out of the state of California. It's a good evening, Mr. Solomon. It's an honor to have you with us. I want to thank you first for being in our show, and it's a pleasure to have you here. I know you're going to be educating us, including myself, and a little bit about bankruptcies and debt settlement. Why don't you tell us a little bit about yourself, Mr. Solomon, please?
Well, thank you, Rafael, and it's a pleasure to be here with you. Thank you for your time. As you have said, I'm an attorney in the state of California. I've been licensed in California for just over 18 years. Been practicing in the legal field for now just over 30 years. I am currently I am the principal attorney for our group called the Oakview Law Group, which is a consumer debt resolution and debt relief platform. Our goal is to help individuals resolve their debt and become debt free. We also have associate attorneys that specialize in bankruptcy and other areas related to debt relief. In addition to working with Oakview Law Group with our debt relief, I have over the last 15 years, the majority of my practice has either been in debt collection or debt relief, one side or the other during that entire time. So I never want to call myself an expert because there's always somebody out there who knows something more than I do. But I do feel quite familiar with the area, especially when working within California. And I do want to be specific on that everything I say today is related to my experience in California. Other states, each state has their own laws in relation to debt, in relation to debt collection, as well as there are federal laws that govern debt collection. But I'm dealing with California. As you can see, 30 years ago I was not a young man. I was not just I was in the middle of college, but I was not in my 20s. So I often get asked, what did you do before coming into working in law? And as I was reminded talking with a couple of friends last night, the most recent thing I did before getting into starting to work in law practices was I was a baker. I was a bread baker at a Las Vegas hotel for 5 years, and it was an enjoyable thing. I tell people I come honestly by my physique because the saying is never trust a skinny cook. Well, I never had anybody come into the bake shop that didn't feel like they could taste anything that I'd made, because I obviously had tested it myself and was doing well. But that was a highly physical job, and due to some unknown physical debilities and disabilities, I ended up having to leave that. And when I did, the question was, what will I do with my life? And the person who posed that to me more than anybody was my wife.
Wow.
How
old were you after you resigned or you quit your job as a cook or as a chef?
I was 30 years old when one morning I woke up and I couldn't stand upright. And like I said, this was something that had been not unknown to me, that turned out to be a genetic abnormality. And within a few months, I was enrolled in college and continued working as a baker for a while, and then went on to Had to work at other things, eventually landing in a law office to see my way through the end of both my undergrad and through law school. But I attribute it to my wife, who I am always happy to say we were still together, that when I said, look, I'm going to have to do something else, maybe I'll go to college, she was the one who posed the question,
inspire you to do that.
What would you do if you go to college? And then when I said, hey, I've always thought about being a lawyer, then she made me sit down and how will you get there? And so I say that because I have found in talking with others, those who are successful, those who have risen above their difficulties, whatever they may be, physical or otherwise, have had to make a plan to do so. There is an old saying that says, if you fail to plan, you plan to fail. And I've become a great believer in that over the years, because if I hadn't been pushed to make a plan, I wouldn't be where I am today. So that is in a nutshell how I got where I am and what I'm currently doing.
That's such an amazing story. So you are, and so you always liked the law school. You always wanted to become. When did you realize that that's was what you wanted to do right from the start, from the early years, or when you reached 30?
I had actually decided in high school that I would like to go to law school. And yet I was, as I've told others, I was already working a full-time job by the time I was 14. And I dare to say that for people of my generation and of my age, that's not an unusual story.
Right. I do agree with that. Yeah. But
so college, I was in Southern California and I had access to a community college, but I really didn't understand the value of that. And so I just, while I knew I'd like to go to law school, I even looked at a couple of law schools. My grades were not quite good enough for scholarship,
right.
And I certainly didn't have the finances to go do it
at
the time. So I went on and went to work. And just continue, it was age 18 on till age 30, working, trying to make a living, starting a family, doing those things.
That's what, 8 to 12 years?
Yeah. Wow. Yeah. In fact, I had shortly after I started in college at age 30, I was speaking with my mother, and she said to me, so what are you going to do with this college thing? What are you going to do with this? And I knew this conversation was coming, and I actually dreaded it. But I just, gritted my teeth, and I just told her exactly what was going on, that I was going to go to law school and going to become an attorney. And her first reaction was, why didn't you do that 13 years ago?
13 years ago.
Meaning when I graduated from high school. And it became a little heated, as I recall, because my response was, who was going to pay for that? How was I going to do that?
Was the money part that was actually a big student?
Oh yeah, yeah, and it wasn't until I was 30 that I learned that, and number one, a lot of the financing options for a higher education had changed over that 12-year period, and it wasn't until age 30 that I actually found that there were options that allowed me, that helped me with that financing and helped me to be able to pursue that goal.
That's great. That's great. I've been watching some. In fact, you and I met each other in LinkedIn, I believe, right?
Uh-huh.
And it was pretty impressed with your profile, Mr. Solomon. I did a little analysis on your like stuff that you have there, and it's kind of caught up my attention that I mean, you are. Tell us about what your expertise in which areas of the you deal with a lot with clientele with bankruptcies and debt management or debt settlement stuff like that.
Well, yeah. My practice falls under the general umbrella of civil litigation and civil practice. And within that, I deal with individuals and small businesses, a lot of the time dealing with options in debt resolution and debt relief. I do not file bankruptcy for people. I'm going to put that out there right now.
Okay.
I've been into bankruptcy court, but it's not the place that I like to be. So I don't practice in bankruptcy. But we have within our network, we have attorneys that specifically do practice in bankruptcy, and I'm well enough versed in it to be able to advise people what the consequences, what the pros and cons may be in filing bankruptcy. And like I say, I've worked with small businesses and individuals. I spent, and part of this came about or started about 2008, 2009 when the housing bubble burst and we started having all these, a recession then. And I specifically was working with a small construction company that had themselves suffered the results of a customer's bankruptcy. And it was one of the most dynamic issues that I've ever dealt with, because my client still is functioning and operating. It was a construction supply company, mostly with concrete. It has a big yard, and they at the time had customers coming in every month, and everybody's on accounts receivable paying within 30 days. And within the same 30-day period, their two largest customers filed bankruptcy. And the resulting snowball effect for my client, I dealt with for the next 5 years. Because, imagine yourself if you've got, half a dozen clients, but the two largest ones there who pay you every month all of a sudden stop paying you, the effect that would have on your livelihood and on your business abilities. And as a result, at one point, I was dealing with 16 different vendors, working out payment plans, negotiating with them. And this is where I got a lot of firsthand experience with looking at bankruptcy court, because that kept being an option that was brought up. Should we go to bankruptcy? And my client didn't want to. And we kept looking at what the pros and cons were, and we actually did not go to bankruptcy. They chose not to, and I can tell you, as within 5-6 years of that start date, they were completely solvent. They were in completely good standing with all of their creditors and operating in the black, on a positive cash flow. And it was because, and it wasn't me, it was because my client had been always had been a good customer with their with their vendors prior to that time, and were more than willing. When I said we need to talk to your vendors, they were more than willing to get on the phone with me, with those vendors, and talk to them about what's going on. And there were some of them where I quite frankly had to say to them, here's what my client can offer. Well,
Good.
this is what my client can offer right now. And I had a couple of vendors that had said, oh no, that's not going to work. And I said, well, the other option is my client files bankruptcy.
That's what the accreditors, the accreditors, what did they say to you after that?
Well, they changed their tune because each of them knew the result of going to bankruptcy, the immediate result of going to bankruptcy.
Which chapter under you were filing for this?
Well, we were talking about Chapter 11 for a corporation, as opposed to Chapter 7, which is what individual Chapter 7 or 13, which an individual has the opportunity to file, or
Mr.
the
Solomon,
option of filing.
Can you tell us what's the difference between? I'm not talking on the business side, but on the individual side of the
right
between the Chapter 7 and 13. Can you just briefly tell us? Please?
Absolutely. A Chapter 7 is the most common bankruptcy filed by an individual in the United States today. A Chapter 7 results in, usually, if it's done properly, will result with a discharge of debts within usually 6 to 9 months of filing. What that means is that if it is properly filed and the rules are followed, an individual filing a Chapter 7 bankruptcy will walk out after that 6 or 9 month period with a discharge by the court, meaning that they no longer owe those creditors and they have a clean slate. They get to start over.
A fresh start.
They get a fresh start, so to speak. However, it does not come without some consequences.
Of course, yeah.
And I just dealt recently with one of those consequences in the state of California. In the state of California, if a creditor or an individual gets a judgment against you, that judgment is valid for 10 years and can be renewed before the end of that 10-year period, and can be continued forever.
Really?
So when a person goes to bankruptcy, that debt, the money owed on that judgment, is discharged. But California law says when that creditor goes to renew the judgment, they have to list all the debtors on that renewal of judgment. So I recently dealt with a client who had gone to bankruptcy, a judgment had been entered against her by a creditor, by a small bank. She went to bankruptcy. It got discharged in bankruptcy. Well, her ex-husband did not go to bankruptcy, so the debt is still valid against him. Yeah. And when the bank, now 10 years later, went to renew the judgment, it suddenly popped up on my client's credit report that there was a judgment against her. And, we went to the court, and the court said they can't try and collect from you, but under California law, and it jibes with federal law,
right,
the creditor has to name you or list your name on the renewal of judgment. So that's one consequence. Another consequence is a bankruptcy, regardless of those things, will remain on your credit report for between 7 and 10 years. Now, that doesn't mean that you can't rebuild your credit and and remedy that, but it will still be out there and will be public information, and there will be creditors that will look at it and say, no, I'm not going to deal with you. There are others that won't. Some of the positives of it, again, like I say, it's a fresh start.
Mm-hmm.
You get you get rid of debt, and you get to start over in rebuilding, in building your credit history and building your credit life.
Who qualifies for Chapter 7 or 13? Who does? I mean,
Well, Chapter 7 and Chapter 13 are available to any individual, and they are also available to corporations, to small corporations, but they are most commonly used by and available to an individual. And it's an individual whose debts exceed their assets. That's the simplest definition of who should consider bankruptcy. Is, I have more debt than I have assets to take care of that debt. And the difference between a 7 and 13 is that a Chapter 13 bankruptcy does not result in a total discharge of debt. A Chapter 13 is a repayment plan.
A repayment plan, yes.
And it's
what percentage do you have?
Well, it depends. It depends. I've seen Chapter 13 plans with get approved at a 50%, but I don't recall seeing one approved at less than 50%. It may happen, but I don't recall seeing it. I see more commonly Chapter 13 plan being approved at a 75% or higher payment on those debts. It's just that those debts are those creditors are accepting smaller payments over a longer period.
Okay.
The normal, not the normal, the statutory period for a Chapter 13 repayment plan is up to 5 years.
That's it? 5 years?
That's what the statute says it's supposed to be, is for 5 years. Now, there may be some special circumstance where creditors and debtors agree, and the bankruptcy trustee who oversees the plan may agree to go beyond that. But the normal is up to 5 years. And that means for a 5-year period of time, that debtor is on a payment plan administered by a bankruptcy trustee, and which monitors and monitors income and monitors cash flow, monitors income, monitors payouts, with the objective of, at the end of that plan period, the creditors will all have been satisfied because they've either agreed to the plan or they're under a court order to agree to abide by the plan. And the debtor has satisfied those creditors. They don't have any of those debts still hanging out there, and they have not, and they've been able to continue building their credit history or during that same period of time. It's not
5 years, yeah.
During that 5-year period of time, and they can, at the end of that plan, they're getting positive reports.
Yeah, we've done that.
Reporting, as opposed to the individual who goes through a 7, who,
I seen results on I don't know if you know, but if we talked about this, Mr. Lyle, I worked for several years in the National Legal Center. It's actually out of California. Have you heard about them? It's a group of lawyers, National Legal Centers. And I helped the company set up a call center years ago. We started out from scratch. I mean, it was me and my boss. Just to tell you a little bit of, I don't mean to interrupt you, Mr. Lyle.
That's okay.
And I did quite well in that field. being the fact that I was new in that, I never did any credit counseling or dealt with any bankruptcies, things of that nature. But we were able to, of course, after training and all that, the company was a real good company. It was lawyers like yourself,
Right.
dedicated to do debt settlement, negotiating with the debtors, with collections companies, and I my part came in when my boss asked me to get a. Hey, by the way, I understand that you speak both English and Spanish, correct?
Yes.
You're bilingual.
Yes. To a
That's good.
point.
That's a good advantage to you, being able to speak languages. But so he asked me to set up a group of people, to start hiring new guys, and we ended up with 67 plus employees, and we did great, man. Well, Mr. Solomon, and for the people out there listening, we helped so many people in getting the credit, you know, fixed on a probably 6 to 1 year. It was, it cost them money. I'm not going to tell you. I mean, there's nothing out there for free, of course.
Right.
But I'm proud to say that the company that I worked for was a great company. It was, and they did their job. I mean, we used to charge these people like $110 a month, and we put them on a credit monitoring service so you can see how the credit will, which items will be getting disputed and coming out of the credit report. So bankruptcies were something that people will ask me all the time. Since I didn't have the experience, I will tell them, well, I just cannot give you advice on that because I'm not. First of all, I'm not an attorney. I'm just a counsel for credit repair. But I see people, including some members of my family, that have filed bankruptcy, and after 6 months, stuff starts coming out. You start rebuilding that credit with a credit card, like you just taught us. So there's help up there. I mean, let me ask you a question, Mister. Another question to move forward with this. Can a creditor or debt collector seize your Social Security? This question was asked by one of my viewers, or similar benefits, Mr. Lau.
No. The most direct answer is no. Social Security benefits are exempt from collection by a creditor. There are ways creditors can try to get around that, but the general rule is no.
No.
The way I've seen creditors try to sometimes end up with an issue that way is if an individual's Social Security benefits are not being direct deposited into their account, but are going into an account where they have other funds going into, such as somebody who's on Social Security and still working. Those benefits, and they put both the Social Security check and the regular paycheck into the same bank account. A creditor may end up doing a bank levy, and what's called a bank levy. And if they do that, they may end up with some of those Social Security funds. But the general rule is
No.
they can't touch your Social Security. In fact, when I was doing debt collection years back, I would often be talking with individuals, and they would say, "Well, I'm judgment proof," and I say, "What do you mean by that?" Because
what do you mean with that? Judgment proof.
It's not a legal term, but they had heard it from somebody. They'd heard it online. And what they meant was, though, is that they didn't have any assets that my client could collect from. And oftentimes it was somebody either on Social Security disability or Social Security retirement. Okay. And I would, my response to them would be, well, we can't collect from those sources, but that doesn't mean we can't ask the court to enter a judgment in our favor. And, there is a difference there. And most of the time, the individuals I was dealing with didn't didn't want to understand that difference or that distinction. So I adopted, when I was doing that work, I adopted a simple phrase to them was, my client would like to go for, if you're not going to be able to pay and enter a payment plan, my client would like to go forward and get a judgment because somebody hits the lottery every month or so, and who knows when if it could be you. And those funds are funds that can be attached by a creditor.
That's pretty amazing. Filing for bankruptcy, Mr. Lyles, is it a bad thing or a good thing? What do you think? Give us your opinion, professional opinion on this. Me and the audience.
I think each case has to be taken individually, and the options have to be carefully considered. I don't. In 2008 through 2012, California had one of the highest number of bankruptcy filings ever in that period of time because of the recession that we had. And and I was in and out of bankruptcy court with clients, and they're observing a lot on behalf of clients. And the thing that I noted was that the majority of people there were people who were had never been in bankruptcy court before, had never considered bankruptcy before, and were truly in a position that they just didn't have a way that they were going to be able to get themselves out of this debt otherwise. And so for them, it was the best option. There were a few others, though, that I saw there who bankruptcy had become part of their routine. And by that, I mean, I met a man who every 7 years he had it calendared that he was eligible to file bankruptcy again, and he did.
How many? Mr. Lyle, excuse me, I'm sorry.
Sure, go ahead.
During my life, during my life, how many times could I file for bankruptcy? For a bankruptcy?
Bankruptcy filing can be done no sooner than 7 years from the last discharge. So if you file bankruptcy today and your discharge was final in, say, March of 2022, you could be eligible to file bankruptcy again the 1st of April of 2029. Yeah. Now, bankruptcy judges have discretion if they see somebody that they look at the paperwork and see that this is just every 7 years they're coming in and doing this, and they're not making any effort to make any changes, and that there is some discretion there, but by law, a person may be eligible every 7 years.
All right. Let's get into the debt settlement. That's one of your expertise, right? In that field, right? Yeah, I'm pretty sure. Would it be possible for you to tell us the truth about debt settlement? Because from my understanding, there's just nobody wants to be drowning in debt, unable to pay the bills, and that's why probably they're afraid to answer the phone to collectors, and they're looking at the possibility of filing bankruptcy. But my question is very simple out there to you, Mr. Lyles. What can you tell us about it? Does it work? What's the truth about it?
Sure. Let me begin by saying that anybody who's considering working with a debt settlement company needs to do their homework and investigate the company that they're dealing with. I say that because over the years, I've been in court with individuals who have said, hey, I signed up with this debt settlement company and I've been sending them my payments. instead of to the credit card company or to the bank or whoever the creditor was. And here's the receipts. I've sent them all this money. And I've been at the same time, I've heard from that creditor say, but we haven't received any of that money. And I've heard that story too many times to count, that, individuals desperate, wanting somebody to help them, have been contacted or have reached out on their own to a supposed debt settlement company that said, send me your money and we'll make this, we'll settle up with your creditor. And it hasn't happened.
So does it work, and who qualifies for debt settlement?
Well, anybody who owes money could ultimately qualify for debt settlement. And the whole reason that somebody should go to a debt settlement company is if they do not have the time and the knowledge. Let me reverse that. Either the knowledge or the time to gain the knowledge to go talk with their creditor themselves. An individual can go talk with their creditor about resolving their debt, whether it be through, hey, let's negotiate this debt down because I have hardship and I can't pay all that, or hey, can we stretch out this payment plan and lower my payment? Any individual can do that. The caution I give on that is that most creditors will not talk with an individual about some kind of negotiation of any type unless they are behind on their payments. And once you're behind on your payments, you are oftentimes better off having a third party who deals, well, much like your former employer, who deals with those creditors on a daily basis and has a rapport and can go in and talk with them. But the big one of the big cautions that I give to anybody in looking at dealing with the debt settlement, they should not be dealing with anybody who asks them to make a payment to the debt settlement company up front of their fee. They should not deal with the debt settlement company who is not willing to show them and give them a record of both contacts with the creditor and the payments made to the creditor.
Well, when you talk about this, be careful with it. Yeah, about 4 years ago, I'm not going to mention any names. I cannot. That's not my. I'm not think a bit bad mouth any company out there, but
right.
It was shut down while I was working. The feds came in, the arbitrator for the assigned by the judge, and they took all the computers, the software, and everything. We were just asked to stay and sign up some documents. It was a big company. The guy was a multi-millionaire guy. In less than a year, he was accumulated a fortune, and we were charging these people. I'm saying we, shame because I was just an employee. But and I did the credit repair part. That's when I was hired to manage a small group of people, and he had like 150 employees. But anyway, what I'm trying to get at is that you're right. I mean, for the people, our listeners that are now with us live or down the road, they need to be very careful. I agree with you, that, Mr. Lyles, because there's a lot of companies, scammers out there taking. I would choose an attorney over one of those credit companies. I mean, the debt settlement companies up there, because there's, especially in the state of Florida, we are famous for that.
Well, I didn't want to say that, but I saw that. I think I saw addresses in Florida more than any other state that these individuals had been sending their money to. And here's the other caution on dealing with the debt settlement company.
Excuse me. There's some good companies out there. I'm not going to tell you.
Right. No, there are.
Like credit repair agencies. I know quite a few, plenty of them that in fact, they're dying for me to, like bringing me with them. But I'm done with that stuff. And also student debt companies that I dealt with in the past for a few years. But it's just people get greedy. This exactly for owners, and they start charging more money. And then when clients give them the credit card, they start over, and that's how all that goes on is consumer rights violations. I mean,
it is, and the other caution that I constantly deal with people on is just because you signed up with a debt settlement company doesn't obligate the creditor to deal with that company on your behalf. And in fact, I had that experience not too long ago where a man came in and showed the judge, here's my letter. I employed this company to deal with this creditor.
So?
And the judge says, well, that's nice that you employed them, but did the creditor agree to deal with them? Where's the letter saying that the creditor agreed to deal with them and not deal with you any longer? And the man just was, you could see the confusion on his face. And that is the caution that I give people, is that your credit card agreement, your loan agreement, anything to do with a creditor is a contract, and it requires the agreement of both parties to that contract. So if you're going to, as the person owing money, if you're going to say, hey, I want this other party, this other company to deal with you, creditor, the creditor does not have to agree to that. And the creditor, and even if the creditor does say, okay, I'm going to, talk with them, it still doesn't get you, the debtor, the original debtor, off the hook with that creditor without some kind of what we call a modification, some kind of subsequent, additional agreement that says, yes, we will deal with ABC Credit Resolution Company instead of you, John Smith. And we understand that they are your agent, John Smith, and they are acting on your behalf, and you want us to deal with them, and we will deal with them. And until you have some kind of agreement like that, unfortunately, creditors have the ability to continue after you, the individual, even while dealing with debt, the debt resolution company also. So it's you have to walk into it with your eyes open. You can't just say, here, I'm handing it off to you, you take care of it, and think that everything's going to be that you're out of it as a debtor. It comes back to what one judge was talking of. I had a judge not too long ago talking about that personal responsibility. You signed up for the credit card. You didn't sign anything else that took away the responsibility you signed up for originally. And until you have something new that says, signed by you and the credit card company, that you are no longer responsible, you still have personal responsibility.
So do we agree that it's debt settlement against bankruptcy? Which option is the best? Which of the two you think?
I don't think it's a cut and dry. There is a cut and dry answer.
Okay.
Each circumstance is different. There are some circumstances where bankruptcy is going to be the very best option. There are other circumstances where going through debt resolution and negotiating and working with a creditor is going to be the better solution. But it's each circumstance has to be taken individually. I couldn't say I would not. I would be roasted. So I would be severely chastised if I said there was a one size fits all on those questions.
Thank you, Mr. Thank you. In case I decide to do my own debt settlement, do I have to know about how to negotiate? For those people out there that are not probably too crazy about paying these hundreds of thousands of dollars to these settlement debt settlement companies, and they decided to do on their own. What if collectors start threatening me and with lies?
Oh yeah, no, there are unethical collectors out there, no doubt. Those that will tell you lies and tricking, trying to trick people. And again, an individual can do it. Can go talk with their creditor and try to do their own debt settlement. Mm-hmm. But they need to go in with realistic expectations,
right?
And with solid facts and figures. If you walk in and your monthly bill has been $500, and you call up your creditor and you say, "Hey, I know I've been paying $500, but some circumstances have changed, and I want to pay $50 a month now to you," your creditor's going to hang up on you. My experience is that the creditor is not only going to hang up on you, but they're then going to, as soon as they finish hanging up on you, they're going to call the attorney or the legal department and say, file a lawsuit against this guy because he's going down the tubes. And we want to be able to, have some legal means to get our money back, or get our payments out of him. Mm-hmm. So you have to be realistic, and have the information available. If your circumstances have truly changed, have that information available and be willing to send documentation about it. Creditors hear every day somebody calling and saying, I'm sure between the creditors I've dealt with in the past, they would have hundreds of phone calls a day. I've lost my job. I can't pay this. I can't make these payments any longer. Well, okay. If you've lost your job, I need to see your notice of termination. I need to see your application for unemployment or disability benefits. I want to see, I need to see that your circumstances have really changed from what they were when you made this application. So as a debtor seeking some kind of resolution with a creditor, you have to show them why it would be in their best interest, or why it would be in their interest at all to help you, because Target is not going to close any of their stores tomorrow if I quit paying my Target bill. If one person stops paying it. And I will tell you that, there are many creditors, that's just an example, but there are many creditors out there that have that attitude, because they know that, excuse me, if one person defaults on their account, there's still 900 others that are using, that Sears credit card or whatever credit card it is, to shop and willing to. So you have to give them some reason and something that will help, assure them that this is not going to just be a total loss.
Okay. Thank you, Mr. Labs. What phone number should anyone interested in your contacting you should dial, Mr. Could you tell the
Sure,
people?
sure. We have an 800 number um, that will put them in touch with me or one of our other attorneys in our network. And if I can give that to you, that'd be great.
Absolutely.
Sure. The number is 800 530 6854. You've also, I think I saw you had my email up there
Yes.
also.
Will that be all
And
right? Will that,
and also anybody can go into our website
I have it.
and with and we have a contact us form there that people can get a hold of us.
Can you give me the number again, Mr. Lambs, please?
Sure. The phone number again is 800
Mhm.
530 6854.
That's in California, and then all right, perfect.
Yep. Yep. But we also are able then to, it's 54, not 55.
Oh, made a mistake. Let me change that.
So somebody else will not be happy getting phone calls.
Okay. All right. Change this now.
But it'll get to me or those phone calls will be either directed to me or to another attorney. We have other attorneys throughout the country.
Oh, really?
So
Good.
if somebody's calling from Minnesota and they don't want to talk with me because I'm not going to be the guy who can help.
So you guys are a group of
law,
attorneys, not on a national level. You're
we have and we are constantly building, adding to our network across the country, trying to have attorneys in all 50 states that because that are familiar with the specific laws in their states, so that we can help people not just here in California where I am, but also in Florida and other states around the country.
all right. I have a guy, a guest that I would like to. Cesar, are you in?
Hey, Ralph.
Cesar, are you in?
Yes, sir. I'm here.
All right. This is Cesar. Cesar is a good friend of mine, Mr. Solomon. He's been a very great supporter to my show on the technical part with the audio, and he just wrote the question. I was just communicating with him if he wanted to just address it to you personally. Go ahead, Cesar. You're in.
Yes, Mr. Lyles. I just wanted to know if let's just say, for instance, what happens when you file for bankruptcy? Like, what happens with your credit at that point after everything is discharged? Like, does it go? Does it take a dive, or is it like you're starting over, or?
Depending on how much debt you have, can have an effect on how big a ding, or how much your credit score is affected. Your credit score is definitely affected by bankruptcy. That's why there exist things like prepaid cards or cards that are directly tied to bank accounts, so that that are secured cards that
Right.
will help build credit back up. That's one of the hardest things in talking with some of my clients that they have experienced after filing bankruptcy, is building their credit back up, because it can take several years to do so.
In your opinion, I'm sorry, this is one more question. In your opinion, so let's just say, for instance, after bankruptcy, and say you wanted to purchase a home, how difficult would that be? And if it is possible, how long do you think it would take to, obviously assuming that the person is doing right as far as trying to rebuild their credit and taking the right steps?
That's a good question, Cesar, because I'll tell you from my experience that depends almost entirely on the creditor, on the bank or whatever entity it is that's going to make the home loan after a bankruptcy. I've seen people able to make home purchases in as little as 3 years after a discharge in bankruptcy.
Oh wow.
But it's the number one thing there is that they have to be upfront about that. They've been upfront with that bankruptcy. And, there's a question on, at least the last time I did a home loan, there was a question on there, have you ever filed bankruptcy?
Right.
And you want to be upfront and honest about it, but you also then, if there was specific circumstances that led to it, you may then want to add a note to that explaining why, or saying I'd like to, or making some kind of note about there being an explanation for the cause of that bankruptcy. Still one of the number one causes of bankruptcy is medical bills.
Right.
And creditors have learned that they can't just look at a bankruptcy and say, oh, this person's bad with money. But if you don't, if you're not upfront with them, and if you don't ask for an opportunity to let them know what was going on at the time, they may just let it, look at it and say, well, there was a bankruptcy, we're done. So it depends on the creditor.
Okay, great. Thank you so much, Mr. Wells. I really appreciate it.
Oh, you're welcome, Cesar. Thank you for the questions.
Thanks, Cesar.
All right.
All right, so that's I guess I'm gonna just close it at that, leave it at that, Mr. Solomon, and we ran a little bit 6 minutes, but that's okay. I loved it. I mean, it's been a pleasure to have you at my show.
Well, thank you for the opportunity, Rafael. Ha sido un placer.
Y el mío, igualmente. I want to thank you once again, Mr. Lyles, for coming into my show and educate us on what has been discussed. I also like to thank you, the listeners, viewers out there, and most important, the audience. This is just about you guys, and we are ending the show in a few seconds. Thank you, and God bless you all. Thank you, Mr. Lyles.
Thank you very much, Rafael. Have a good evening now.